What's up, guys? Today we will be looking at motion for protective order to coordinate the position scheduling by Destiny. We are not going to look at the motion because this is basically exactly the same thing which is in the attachment 1, which is affidavit of Bredla. It's basically the same thing but with more words. I've looked through it, it's literally basically the same fucking shit. So we don't have to look at this with how many pages? 12? No, 10. 10 pages. 9 pages. 9 pages. You can just look at this 6 pages. So it's basically the same fucking shit. If you don't believe me, you can look it up yourself. Yeah. Declaration of Andrew Bledla. Bledla. I, Andrew blah blah, nobody cares. I submit, nobody cares. On September 17th, Joanne Peters, on behalf of plaintiff Jane Doe, inquired about scheduling Mr. Bonnell's in-person deposition in Miami, Florida between October 25th, 22nd, 2025 and November 19th, 2025. This is important. We're going again to draw a picture. And this will be the picture. We're going to keep it super simple. October 22nd to November 19th. There will be time for Depo for Destiny. This is what they said. There's just time for the positioning Destiny. And this is what they said. So let's color it yellow. So they basically said, okay, from this time to this time, we are ready to position Destiny. Okay, nice. Good, 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 good. Everything fine. Attached email. Should we go through emails? I think maybe we should. Exhibit A. From Joan Peters. Day 2 Bredla. And obviously those are everybody who's included, obviously. Council. Discovery cut date as the court scheduling order in December 16th. Cut off date. Discovery. Okay, so Discovery ends in December 16th. With that in mind, we would appreciate if you could provide 3 available dates for the defendant to depose in Miami between October 22nd and November 19th. I also don't understand. How do you type in this, but you don't type TH in the end here? Maybe I'm just not understanding English language, lawyer language, whatever. Once we have agreed on a mutually available date, B will provide the notice of the position. Once we have agreed on a mutually available date. On September 22nd, I respond to Miss Peters writing, Mr. Bonnell was generally available during the first week of November and for logistical reasons suggested that the parties schedule plaintiff's deposition for the same week. Exhibit B. Exhibit B. Exhibit B. Our client is generally available during the week of November 3rd, with the exception of November 4th. I have a court hearing in another matter. We will endeavor to make Mr. Bonnell available for deposition any day that week. While we are in Miami, let us also set plaintiff deposition for the same week. Please let us know what works for you and her. Thank you. Super easy. Hey, the week of November 3rd is fine. The only date which doesn't work is November 4th. So basically, this Denny's lawyer say a week of November 3rd is fine for Destiny. Boom. Easy peasy. With the exception of November 4th, of course, as we can read here. Okay. Attached here to Exhibit B. On September 26th, Ms. Peters indicated that plaintiff wanted to take Mr. Bonnell's deposition on November 5th or 6th, but claimed that plaintiff would not be available for deposition during the entire month of November because she was going to be out of state. Exhibit C. Let's put down the picture first. So, entire month of November. Entire month of November. Plaintiff Pixie not available during all month of November. Hello. Hello. Oh. Let's do this properly, I guess. Pixie not available during all month of November. Yeah, so this is correct. Okay, now the picture is working fine. So yellow is what Pixie's lawyer says, and blue is what Destiny says. Exhibit C. Exhibit C. We would like to depose your client in Miami on November 5th or 6th. Please confirm availability. Our client will be in Illinois, not Miami, in November. Which is weird. Then why did you not depose her earlier? In my opinion, because deposing her in the first 2 weeks of December is cutting it close. She's available to be deposed remotely. Nobody cares about that. Or in person in Illinois. Nobody cares about Illinois on November 14th. Nobody cares about this. So basically this sentence is completely useless. Because nobody cares about remotely, nobody cares about Illinois. It's kind of weird that you say our client will be in Illinois, not Miami in November. This is super disgusting. Because she should be ready for the position in Miami. But okay. Do we have to change the picture? Not available during November. She's available November 14th in Illinois. Nobody cares about that, so this is not even a statement. Okay. Within a couple of hours, I responded to Miss Peters and agreed to hold. This one is important. To hold November 6th. What does it mean? What does it mean to hold a date? To hold a date means to temporarily reserve or block a specific date for an event, okay? Appointment or booking. Basically the same shit. Often as preliminary step before final confirmation similar to save date or in a more formal context. To keep the reserved on a waitlist until a decision is made. Until the decision is made. Before final confirmation. Until a decision is made. We can continue on reading. It is used for weddings, conferences, or travel bookings where you want to ensure a date is free without committing fully immediately, allowing a brief window to finalize details. You can easily Google what holding a date means. I just did that. Apparently, Pixie's lawyers are not smart enough for doing so. Not only that, they should know so anyway, what this means. Or they do know and they're just fucking lying like they always are doing, which is more probable. Given plaintiff's counsel's representation that their client was not available for an in-person deposition in Miami during the entire month of November, which they have said, I asked plaintiff's counsel to provide her availability in October. Exhibit D. Let's look at Exhibit D. Thank you, Joanne. Let's hold, and it does say here, let's hold November 6th for Mr. Bonnell's deposition in Miami. 100% fine. If your client is not available for the position in Miami during the entire month of November, please provide us with the ability to sit for the position in Miami in October. So they just asked, okay, this is your time frame, but you also said this is fine for us, this is not fine for you. How about October? We can easily go ahead and do this. Um, does Pixie have time in October? Question mark, question mark, question mark. That's what Bradler is asking. Yellow, no, blue, and these. Okay. Maybe it shouldn't be until here. Maybe it should be like until here. Whatever. Doesn't matter. On September 29th, plaintiff's counsel noticed. This is the funny part. On September 29th, plaintiff's counsel noticed Bonnell's deposition for November 6th. So they basically went on ahead and said, we are not holding November 6th. We are making you agreeing to November 6th deposition. And then they said, November 21st. Plaintiff is fine with to be in Miami. Not the same with Plaintiff was supposed to be out of state during the entire month of November. Exhibit E. Let's keep on drawing our picture. So suddenly, Pixie's lawyers are like, well, uh, November 21st, she's there. November 21st, she is there. After saying Pix is not available during the entire month of November. But November 21st, she is. Exhibit E. So let us look at Exhibit E. Attached, please find a notice of deposition for defense deposition on November 6th. Which is so fucking stupid. How can you do this, you stupid as fucking whore? November, you just a miss, not a Mrs. Joanne. Nobody wants you, stupid fucking ass. Plaintiff can be away Miami on November 21st. How? You said no the entire month of November she isn't. How suddenly she is? And how are you immediately noticing him for deposition? It was told you to hold the date. I fucking hate stupid people. I promptly advised Miss Peters that my colleagues and I had a conflict on November 21st due to a previously scheduled mediation in LA. I again inquired about plaintiff's ability for the position in Miami anytime in October. Exhibit F. Exhibit F. Thank you, we will calendar some position for number 6. We have a mediation in Los Angeles on November 21st and can take resolution that day. Per my prior email, please avoid us dates in October for plaintiff's position in Miami. Calendar still does not mean that they are agreeing to this. Calendars mean they're still holding the date also. They're like, okay, no, you can still change this shit. And again, they ask the second time, what about October? On September 30th, by the way, it's getting closer and closer to to October 22nd. Miss Peters offered additional availability for plaintiff's deposition in November. Plaintiff can also be available uh, in Miami on November 24th and 25th. Huh? But what about not available during the entire month of November? Now she's also available at uh, has time on 24th, 25th November. Suddenly there's even more time for plaintiff. Like now she suddenly offers 3 dates in November. Like how? I understand that things could change, but there's not really much which can change for a fucking student. Whatever. Attach here exhibit G. Do we need to read this? I don't think we need. Everything was right what Bretler has said. Plaintiffs can also be available to be deposed in Miami on November 24th. How? And on those 3 dates, suddenly there's 3 dates. At first there was none, and now it says plaintiff is not available in Miami. But it is. We know you're lying because she is. She can be a remote position. What? Nobody cares about remote depositions. On October 2nd, and Life Plaintiff's newly offered availability at the end of November, I suggested in an email to plaintiffs' other attorney of record, Carlos, that both plaintiffs and Mr. Bonner's deposition to be conducted in Miami 24th and 25th respectively to avoid having to make multiple trips to Miami only a couple of weeks apart. Yes, for convenience. For destiny. Because he has to fly this motherfucker out. Which costs a lot of fucking money. Because Bradley is a lawyer. Exhibit H. Exhibit H. Regardless of where plaintiff now resides, she filed this lawsuit in the Southern District of Florida. Our client is entitled to take her deposition there, in person. This is true. Her argument that it would be an undue burden to sit for a deposition in Miami because it would force her to miss classes. Oh yeah, that's what they said. She's going to miss classes. Please. You can depose her in Illinois remotely. Nope. This is her own fault. There's no deposition in Illinois. This bitch ass needs to be in Miami. It just doesn't fly. It doesn't. It literally doesn't. And also they said she's going to miss 3 days of classes. Bruh. Which is the most retarded argument to not appear before court. Ever. Or just to miss a court-like appointment. Why? I can easily simply just prove it to you. Have you ever been sick and missed 3 days of classes when you were in grade school, when you were in college, or have you ever missed 3 days of work because you were maybe sick? Did it ever happen to any of you guys? 100% it did to every one of you. So this is not an excuse. This is the most retarded thing you can come up with. Oh my god, she's going to miss 3 days of class and this is because she's going to fail. Just fucking go to school and then just like, hey bro, have you been in class for the last 3 days? Yeah. Okay, may I copy your notes? Okay. Okay, cool. Boom, done. That's how easy it is to keep up. Just say. So this is not an argument on plaintiff side. Oh my god, she cannot appeal because she's going to miss 3 days of classes. Yeah, this is not an argument. This is literally not an argument. And every single fucking judge can look at this and be like, yeah, well, this is literally not an excuse. 100% it is not. On October 3rd, Carlos rejected my proposal and insisted that Mr. Bell's deposition proceeded on November 6th. Why? Why is it so important to be November 6th? Attached Exhibit I. Good morning, I hope everyone's doing well. What does this even mean? Why do you say this? Let's please not confuse the issues. There are no issues, you're creating them. Your client's position is set for November 6 as agreed by the parties. No, they were not agreed by the parties. You are lying. The issue is the method and the dates of a client's deposition. Well, there's no an issue with your method. Your client has to be in Miami. Number one, she just has to be because she she chose to be. And the date. Well, you said it's fine for Destiny to be deposed on November 24th and 25th, which means she can be deposed on November 24th or 25th. You have 5 days to pick when to depose our client. No, you don't. This is not true. Number one, if you have to depose her, there are literally 0 dates. Because, number one, dates suggested are either not in person, either in Illinois, or either. No, that's it. Not in person or in Illinois. They have to be in person in Miami, and that's it. Which means there are 0 dates to pick. Or either not close to Destiny's deposition on November 6th because you don't want to um, change the date for some fucking reason. So there are 0 dates because neither in person, neither in Miami, or neither close to Destiny's deposition. So he has to fly his lawyers out twice. Or his lawyer out twice. Mr. Bretler. Please let us know when you are going to take her deposition. Also, to the hardship. As to the hardship, its negative impact that it will cause on her studies, among other issues. Bro, 3 days is literally nothing. Go fucking kill yourself. I hope it. He is already dying anyways. Who cares? So who cares? I hope we can all appreciate and understand that being the case. No, missing 3 days of fucking classes does not cause an impact on your studies unless you are super retarded and fucking brain dead fuck with missing half of your head and you only have one eye, one tooth, no tongue, no hands. Then I understand that it's how 3 days missing 3 days of classes may impact you. But if you're just a normal human being, nobody cares. Imagine in your fucking school, in your classes, or at your job, you're like, oh, if you miss 3 days, it's over for you. It's done. It's fucked. You're dead, bitch. No, 3 days is nothing. It's not even 1 week. It's 3 days. Who gives a fuck? 3 days. Again, you claim the position is for November 6th. Nobody agreed to it. Please let us know when you're going to take our client's position. Oh, well, we are. No, thank you. Well, he says, like, oh, yeah, 5 dates to choose from. No, they don't. They have 0 dates to choose from. In the afternoon of November, October. Why am I always in November? October 3rd, I request a telephonic meet and confer. So he was like, these motherfuckers retarded. Let's just talk on the phone with plaintiff's counsel to discuss their apparent stalemate in scheduling both the position during the week of November 3rd, or both during the week of November 24th to minimize unnecessary travel and reduce expenses. Which is fine. Because there's no need for Destiny to pay twice if the motherfuckers can depose him on November 24th or 25th. Exhibit J. Carlos. We aren't confusing the issues. We are trying to schedule Mr. Bonnell's deposition and plaintiff's deposition around the same time in Miami for practical reasons. Yes, everybody knows this. In that regard, plaintiff can either appear for an in-person deposition during the week of November 3rd if Mr. Bonner's deposition is going to take place on November 6th, or she can appear for the deposition in Miami on November 24th if plaintiff wishes to take Mr. Bonner's deposition on November 25th. If your client is unwilling to sit for in-person deposition in Miami, where she filed her lawsuit, anytime this month, we are not going to agree to produce Mr. Bonnell in Miami on November 6, only to have fly back there 2 weeks later to take plaintiff's deposition. Plaintiff's position is simply unreasonable. Happily to discuss by phone in advance on Mr. Bonnell's seeking relief from the court. Please advise of your availability for a meet and confer call on Monday. Basically saying, bitch needs to be here in person. And you have 2 weeks. November 3rd week or November 24th week. Prior to meet and confer conference on October 7th, Carlos attempt to limit this. This is also fucking disgusting. Carlos attempt to limit the scope of conference to the schedule of plaintiff's deposition. Basically, they are not even putting up for discussion that Destiny's deposition needs to be changed or can be changed. He once again insisted that the position needs to be on November 6th. Why are you so fucking driven to be on November 6th? It's just that they just change it. We do not agree to change or cancel your client's position. Which is like super disgusting, retarded, like we already know. Pixie and her retarded lawyers are both fucking brain dead. They all are. Good morning. I hope you're all doing well. Why is he always typing this? Obviously, you're not actually thinking this. So this is a lie already. The only issue on the position schedule is when and how you will take this position. No, it's not. It's not how you will take this position. It's going to be in person. In Miami. When is the issue? So this is line number one in first sentence, line number two in the second sentence. Your client deposition date was agreed by the party. Line number three in the third sentence, and properly noticed. Number four in four lies in 3 sentences. This is disgusting. Short sentences too. Respectfully, only a court order or agreement by parties may cancel or move the deposition. Can you not just ask for it? And by the way, also you did not have to notice him immediately after they said hold November 6th. You did not have to do this. It was made by you. And by the way, it's all easily read by the judge. Everybody can read this. If I can read this, the judge is going to fucking rip your assholes apart if when he's gonna read this. We do not agree to change or cancel class position. This is so fucking disgusting. Thank you. This is just like, we are not going to change it. You did not agree to this. We just simply put you down November 6th. And you're never ever fucking talking about this anytime anymore. And this is an issue that how she's going to be deposed. No, she's going to be deposed in person in Miami. They fucking try their hardest to avoid. We have seen that plaintiff is fucking retired during the hearing of her preliminary injunction. So, fuck. We were also fucking retired during this hearing. Shit. We cannot appear. We just cannot do this in person. We just can't. We are too retired. We just can't do this. If we do this again, if there's one more hearing, we are fucking dead. Because every single hearing we had, we've been just losing and losing and losing and losing. Over the course of the several emails, counsel summarized their respective arguments regarding the position scheduling issue. Oh god, L. L. It's the L. They're getting the L. Oh God. But yeah, I feel like you have to read this. Now this is again the retard Joan Peters. Retard number one in this case. No, actually retard number one is Pixie. This is retard number two. And Carlos is retard number three. We don't need your agreement to take Mr. Badot position of Canada, so that it can be scheduled close to time play of the position. If you are unwilling to cooperate, we will seek court's intervention. So now they're threatening. The court will tell you to do so. But nobody agreed on November 6th. Not only is it simply a matter of common courtesy and professionalism, bro, they are arguing for destiny again. To avoid inconveniencing parties, yes, you're inconveniencing destiny. And counsel with unnecessary travel, yes, you are inconveniencing Bretla with unnecessary travel. 100% correct, you fucking stupid whore. Oh my fucking gosh, she's retarded. Because she doesn't have to travel because she already is in Miami. Oh, stupid ass motherfucking bitch. I need to take a breath of fresh air. Whew. Okay, so they are arguing for destiny. Not only is it simply a matter of common courtesy. Exactly. Fucking be where you sued the defendant. And professionalism to avoid inconveniencing parties. Exactly. Be in Miami. And counsel. Exactly. Bradla needs to travel to Miami. You don't. Both of you don't. With unnecessary travel. Exactly. It is a matter of common sense and practicality. That's practicality, whatever. They are arguing for destiny in this sentence. That plaintiff refused to make herself available for the position of Miami is retarded. Where, as you point out, she filed her lawsuit, yes, at any time during the month of October, and refuses to coordinate the parties' respective deposition in November is unreasonable. She is not available in November with Destiny's time frame. She is not available in October. She is not available in the beginning of November. So this is unreasonable. She is available at 25th, 24th, but you don't want it to. Of course this is unreasonable, because you said she's available. 24th, 25th, she's available. Regarding the additional matter, but you don't want it to be. This is unreasonable, that you don't want it to be. Next to Destiny's deposition. Regarding the additional matters you wish to discuss, please see our letter correspondence dated, blah blah blah, to date where you notice from you or your core counsel. Oh, really? There were no. Agreement. Stand that you are based in California, however, defend represented by two Florida attorneys who can person to defend the position. Appear remotely if you. No, he prefers to be there in person. It's as easy as that. And light. of these facts, existing discovery schedule, we intend to proceed as noticed. You noticed for no fucking reason, out of nowhere. Regarding the additional matters to discuss and permit the following defense failure to provide answers, blah blah blah, defense compete, deficient document production. No, everything is fine. He provided you everything. You don't have shit. No, yep, just basically a lot of lies, retardation statements. Nobody said that this is a case in California. Nobody ever said so. Peters is retarded as fuck. L, yep, that's her L. Again, once again, her L. Beginning on October 7th, Council of Record for the respective parties met and conferred telephonically to discuss the dispute over the position schedule. To further accommodate plaintiff and her counsel, I agreed to proceed with Mr. Button's deposition on November 24th to be followed by plaintiff deposition on November 25th. Plaintiff's counsel rejected that proposal too and maintained that Destiny has to be there on November 6th for his deposition. No matter when plaintiff's deposition is going to be. Following the meet and confer call, Destiny was like, fuck this shit. She's going to be noticed on November 3rd. Which is fine. How long did he wait? How long? Following the meet and confer call. When was the meet and confer call? On October 7th. When did this entire fucking shit start? On September 17th. So 3 weeks later, Destiny was like, okay, bro, I've had enough of this shit. They suddenly noticed me on November 6th, even though he never agreed to it. So let's just do the same fucking stupid shit and just notice her on November 3rd. Let's just go ahead. Hey, if that's how they want to do shit, that's gonna be fine. This is how we're gonna do shit. But looking back now on, I understand Destiny's frustration, but he should have just been like, okay, whatever the fuck. Depose me November 6th, and we will depose you November 24th or 25th. And it would have been already done. Now, December 20th, 2025, I don't think neither of them still have been deposed, which keeps this case going on. On October 8th, Ms. Peter sent me an email demanding to know what defense position is about plaintiff's disposition motion of protective order to prevent plaintiff's deposition from proceeding November 23rd, 2025 as noticed. In her email, Ms. Peters falsely speculated Ms. Muller's desire to have both parties' deposition occur close time for strategic reasons. What is the strategic reason? What would be the strategic reason? What could possibly be the strategic reason? She further falsely claimed that defendant insists on first deposing plaintiff. So because this shit happened off record, telephonically, this bitch is allowed to lie, huh? He could also assume that Bradley is lying, but I don't think so. Because the only thing Destiny wants is to be close to each other, no matter who goes first. And looking at everything else which they have said themselves, they have lied about 20,000 million times. In their, like literally, I found 4 lies in 3 sentences. 3 short sentences. And just now, in this video. Yeah. And then she was like, strategic reasons, and he wants her to go first. Nobody cares. No. As explained in my sports, there's no objection to the decision to proceeding first. Okay, so he said it himself. As both decisions could be scheduled close in time to avoid unnecessary time, travel, and expense. The parties, respecting the position, can now be conducted during the week November 3rd in any order plaintiff wants. Because they already noticed her. Now it has to be in the week of November 3rd. Now November 24th and 25th is fucking out of the window because Destiny noticed her. Because they noticed Destiny on November 6th. And he noticed them on November 3rd because they noticed him on November 6th. 3 weeks earlier. So, but and we don't actually need to keep on reading this shit, right? Just end. Joanne, no objection to you deposing Miss Bonnell first. The very first fucking sentence. Even though it's customary for plaintiff's position to be taken before defendants. Oh, is it actually? I did not know this. It might be true. We can actually maybe even look at this. Yes, it is very common and often strategically best for the best for the plaintiff's deposition to happen first as they initiate the lawsuit and hold the burden of proof. This is true. Allowing the defense to discover the plaintiff's version of the event. Lock in testimony and prepare counter arguments. So Destiny is even giving it up, even though it would be better for him to go second. And it is customary to go second for him. Why plaintiffs often go first? Bro! Joanne, how are you fucking up? My Google search just destroys you. Again. Discover strategy. The defense gets to learn what plaintiff knows. Of course. Because she doesn't know. But the problem is she knows that she knows nothing. Find evidence for their side and see how plaintiffs represent. By the way, in one day he cannot fucking find anything. When sworn record testimony sets a baseline. If they change it at a trial, the defense can use the position to change that. Okay, so strategically, it would be better for defendant to go second. Okay, but even then, Destiny was like, yeah, I know that you ain't got shit. You ain't gonna say shit. You can go second. I don't care. He even gave this up. That's, oh my god, this looks so good for Destiny in front of a judge. Oh my retarded fucking lord. Joanne, you are retarded. Even if she was right. Even if she was right with, um, He only wants to go second for strategic reasons. Who cares? Because this is apparently how it normally goes. And obviously a judge would also know this, which means this is not an argument. This is just obvious. It's like her saying, "Oh, he only wants to go second because the sky is blue." Well, I yes, yes, Joanne. Uh, but the sky is blue. I'm sorry you don't like this. The sun does shine, give us light, and provide warmth. Sometimes it's hidden behind clouds, but it still provides light and warmth, Joanne. So even if Destiny said, yeah, of course I'm doing this for strategic reasons, doesn't fucking matter because this is normal, because those are just facts. Defendant goes second, apparently, usually. Okay, but Destiny even gave this position up because he knows she ain't got shit to say. She has no evidence. Exhibit N. Are you looking at Exhibit N? Oh yeah, we are looking at Exhibit N, right? Yes. Uh, it's customary for plaintiff's deposition to be taken before a defendant. So this is true. I did not know this. Destin even never said this in his videos. I think. Maybe I don't remember. I tried to make that clear during my call yesterday, but it was continually interrupted, so he couldn't even talk. Because they had no judge who's fucking them. The only issue is coordinating the schedule of the two depositions so they could occur during the same week. He also should say in Miami, but they already stated that they are too retarded for all of this anyway, so who cares? We'll even leave it up to you and your client. The parties' respective depositions can either be conducted during the November 3rd or November 24th in any order plaintiff wants. You offer that defendant can depose plaintiff remotely. It's not acceptable. You offer that defendant can depose plaintiff remotely is not acceptable. Well, because obviously in person is way more efficient. Plaintiff filed a federal lawsuit in Miami, Florida, which needs to be there. Defense is entitled to take a deposition there. True, the general rule that plaintiff who brings suit in a particular form may not avoid appearing for examination in that forum. True, I have read this shit. I have read that rule. Blah 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 blah. In accordance with this general rule, a plaintiff must make herself available for deposition in the judicial district in which she filed lawsuit. Blah 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 blah. Denying motion for protective order for deposition to occur via Zoom. Whatever. Okay, this doesn't matter. Please advise defense position about plaintiff's deposition motion order pursuant in connection with the unilaterally noted position of plaintiff November 3rd despite knowing of her unavailability. To summon a plaintiff's position, we believe that you claim that you are unable to come to an agreement with us about a reasonable date when the position plaintiff is unreasonable and disingenuous and does not justify and you literally noticing of the deposition, especially after plaintiff courteously agreed to deposit. It doesn't matter because you noticed him on November 6th for no fucking reason. This professional courtesy was clearly not returned. Of course it wasn't returned because because you fucking made the first retard move. You wish to deposit plaintiff prior to defend its deposition for three reasons. Number one, this is fine. This is how it usually goes apparently. Number two, no they don't. So, lying. We have no reasons to believe otherwise. You have every reason to believe otherwise. Another lie. Because we have offered numerous dates. Because they have offered you to go first. On November. No, not in person, not in Miami, not close to defendants. Which means no, you didn't. Well before the discovery cover. For plaintiff to make sure will for the position, this includes the only reason for her not able to come was she's going to miss 3 days of classes. This is disingenuous. Missing 3 days of class means literally nothing. Nobody cares. Everybody has missed 3 days of class. Everybody did. Once in a lifetime. Remote does not fucking care. Remote, in person, yes, but Bradler said they can't because they already have another appointment there, which means this is not. You cannot fucking type this again after you already know for days or weeks that Bradler is unavailable there. You cannot type this out again. Also, remote you can also not type because obviously they wanted to be in person. I'm involved in person and I'm there in person. Okay, this was fine. They tried to do it, but you said no. Oh my god. It is difficult to conceive that no lawyer at your firm is a. Nobody cares. No lawyer. He is a lawyer. Bradler is a lawyer. A lawyer. The lawyer. And it has to be the lawyer. Because he is his motherfucker number one who has been there at his hearing. He is the motherfucker Destiny's paying for. Your firm is not available to any of these proposed dates, and you never explained the refusal agree. Well, he did! Logistical reasons, he did! He said so! Traveling twice instead of just one time. You motherfuckers don't need to travel because you are already there. Confirm that you are available on the but insist that defendants already notice the position, which is you can move it, you can change it, and by the way, why is it already noticed? Nobody agreed to this notice to be moved to November 25th. Clearly because defendant insists on first deposing. Wait, what? You, in fact, confirmed that you are available on November 25th, 24th, 20, I hate English, 24th and 25th, but insisted that defendants already noticed the position be moved to November 25th. Clearly because defendant insists on first deposing plaintiff. Like I said, this is how this shit usually goes. We just looked it up. You know this, everybody knows it, I know it, you know it, everybody knows it. These oppositions are unreasonable. Also, later on they said it's fine to fucking switch up those dates. Obviously this before, I think before. Yeah, and then you are playing it once, okay. You don't have. You wish to depose plaintiff prior defendant's deposition. And then she's like, no, we don't care. And then she says it again. And he like, no, no, we don't care. We don't care. Moreover, your position of defense counsel would be inconvenienced by having to travel to Miami twice. Your position then defense counsel would be inconvenience. Defense counsel is not inconvenienced. Defense counsel is fucking happy to fucking fly out for free to Miami, stay in a nice hotel in Miami, and fly back to LA for free. Not for free, getting paid for this actually. No, for free and getting paid for this probably too. And she's like, this is basically a free trip because you can do your work on the plane. You can just fucking pull up, pull out your laptop out of your backpack, suitcase, whatever the fuck, and just type some shit down which you already have prepared anyway, probably from all the other cases which are similar to this shit. If you're already an experienced lawyer, which he obviously is. Oh my god. Also, your position at defense counsel would be inconvenienced by having to travel to Miami twice. No, and not the defense counsel who would be inconvenienced. It's the defendant because he has to pay for all of this shit. And nobody said that defense counsel would be inconvenienced twice. They only said it would be stupid for us to come twice because defendant has to pay for this shit. Your travel preferences are not good cause. It's not his travel preferences, it's defendant spending his money for his traveling. Oh my god. Should this position not be moved? The request in the same motion leave attend. Wait, what? Plaintiff will request in the same motion leave to attend her November 3rd notice deposition remotely. Nobody cares about you being remotely. No. Can defense deposition that would be inconvenience for defense counsel to him twice. Used to agree to such remote deposition. Please articulate your reasons such as they any travel expenses. They already said so. Did they not? Or did they just say it here? Oh, they said because defense is entitled to take the position there. And that's the general rule. And she may not avoid appearing for examination in that forum. If Mr. Bregda's example is correct, but I assume it is. Must make herself available for the position in the judicial district in which she filed suit. Well, of course. She filed suit in Florida, be in fucking Florida. Who gives a fuck that you suddenly moved? Like I said, she's arguing for destiny. She said, travel expense. You cannot be fucking saying no only because of travel expense and time and inconvenience. Exactly. Exactly, Joanne. Plaintiff cannot be saying no because of inconvenience by travel expense because she was the one who sued him there. Good fucking shit, Joanne. You're arguing for destiny once again. Pixie's lawyers are arguing for destiny so many times. It's incredible. On November 10th, Miss Peters indicated an email to that the reason plaintiff will not agree to conduct Mr. Bonner's deposition of member is because she and her co-counsel are not both available. Okay. Now she's saying we are not deposing him there because we are both not available. But she only said it on October 10th? Could you not have said it like a month before this, on like October, let's say on September 20th, or like 3 weeks before this, 3.5 weeks before. You could have easily said this, could you not? Before the fucking meet and confer via telephone? Previously, plaintiff's counsel indicated otherwise. Well, yes, they indicated. They didn't say, but they indicated. That's true. Attached exhibit O. We don't even need to read their shit. Obviously, they're just lying and stupid shit and just trying to make retarded arguments. Why they are not deposing Destiny in the same time frame as Pixie. Thank you for your response. As informed you prior to noticing plaintiff's deposition November 3rd, she is not available. Everybody knows this. Nobody cares about remote anyway. On that day, she will not be appearing. Everybody knows this. She is available on the. Everybody knows this. We plan on proceeding with the agreed and notice deposition defendant. I'm like, don't worry, she will not be there. Now, while instead you might be inconvenienced, while we understand that plaintiff is inconvenienced by having to travel twice to Miami, the fact remains that this matter is pending in Miami. Exactly. Why the fuck is plaintiff not in Miami? Good shit, Joanne. Defendant resides in Miami. Plaintiff resides in Miami, or should be in Miami. No, if she resides in Illinois, then she's retarded. And defendant has local counsel in Miami, and plaintiff has local counsel in Miami. You have not represent any good cause. Plaintiff has not represent any good cause. Need to change that agreement. Yeah, she should be on November 3rd in Miami. Alternative is that both depositions take place during the same week. Here, well, at least Bradley said yes, logistical reasons. They are called Destiny paying money. This is the reason. And he did say so. In the very first email, I think it says logistical reason, or a word similar to logistical. Carlos and I are not both available on. Thus, we cannot agree moving defendant's position. You're both not available, but you clearly never said it before. Now you're saying it, and clearly. Okay, number one, they never said before that they're both not available. Number two, if you say 25th, 24th, 25th, 24th, 25th, 24th, 25th, 24th, 25th, 24th, 25th, 24th, for plaintiff is fine, for plaintiff is fine, for plaintiff is fine. Suddenly, yeah, but for defense, we can't. We just can't. It's just impossible. Fucking retards. We heard nothing from plaintiff counsel for weeks. Then October 27th. Peters emailed me object to plaintiff's deposition proceeding November 3rd. So again, she said the same shit as in Exhibit O. She will not be there. I responded, hey, bitch. We will proceed with her deposition unless protective order, or make it sure that the parties schedule it at the same week, basically. Later, plaintiff counsel replied, we will not waste the court's time or plaintiff's resources. But you did. Number one, we will not waste the court's time. Lie. This entire lawsuit is a lie, is a waste of court's time. Lie number two, bro, one sentence she can already pull in two lies. Or plaintiff's resources. Nobody is wasting plaintiff's resources. Plaintiff is wasting the resources from her donations and her parents or friends. I don't know who the fuck is paying for this shit, but it's not plaintiff's resources. And everybody knows it. You know it, I know it, everybody knows it. By filing a motion for protective order. Now her argument is, we are not wasting court's time. But you are. Literally doing this entire thing for about a year almost is wasting the court's time. I'm gonna say it. Bad things will happen to bad people. And guess who the bad people in this court case are? It's Joanne, it's Carlos, and it's Pixie. I responded at blah blah blah, making it clear that plaintiff failed to appear for if plaintiff failed to appear for her notice deposition on November 3rd, then Mr. Badeo would ask the court reporter to record a notice of non-appearance for the record. Which means, bitch, the fuck did you not show up? It's funny how she says, we will not waste the court's time by filing a motion for protective order because you unilaterally scheduled a notice of deposition. Again, she's arguing for destiny. But 3 weeks before this shit, she was like, we are noticing, we are unilaterally scheduling a notice of deposition on November 6th for destiny. She's such a stupid whore. Fuck me, bro. I just need to fucking punch her in the face. Just somebody needs to fucking go up to her and just fucking punch her in the fucking throat. Notwithstanding the foregoing correspondence and the fact that plaintiff still had not filed a motion seeking protective order. On October 29th, plaintiff's counsel sent an email inquiring about the attendees of at Mr. Bonner's deposition. In response to plaintiff's counsel by email October 30th, reiterating that unless plaintiff appeared for a notice deposition on November 3rd, Mr. Badeo will not be appearing on November 6th. On November 3rd, I appeared at 10 a.m. I went till 10:30, and I prepared plaintiff's deposition. Her counsel appeared, and no time prior to the commencement of plaintiff's notice deposition did she file a motion seeking protective order. So she told nobody, not officially, not officially. She said it in emails, of course. Everybody said in emails, she's not coming. Okay, this is fine, but you have to file a protective order because the court needs to know that you're not coming. It's like fucking Donald Trump. Do not come. And plaintiff was, I'm not gonna come. But the court still needs to know. Okay? Why did you not tell us that you didn't come? That you're not going to come? And why? And the plaintiff's counsel previously indicated, indicated that they would not waste time or resources. I asked them then as a cost, and now you can see why. So Destiny basically paid $1,100, not 1,100, $11,000 because this bitch just did not appear. She could have filed a protective order, then Breda didn't have to fly over there, fly back, take an Uber, take another Uber, take a hotel room, prepare a motion for protective order. He would not have to done any of this shit. The court reporter would not have to be there. So yeah, they basically fucked up again. And we're going to look up even more of their fuck ups during this entire walk showcase, which is so funny. How, bro, I can find four lies in 3 sentences. This is disgusting behavior. Like, how stupid is this bitch? This is so stupid. It's incredible. Like, how can you do this? Why did we look at this? Because it's the easiest to understand. Obviously, we did not start from the beginning. The beginning would be February 2025. We just looked at something from November 4th, 2025. But I think it's just super easy to see how retarded they are and easy understand. Because there was nothing for them to do other than Pixie, bitch, just miss 3 days of classes. Just get your ass over here. Because you have to. Because you did file a lawsuit in this fucking district. You did do it in Florida, so get your ass over here and let's just get this over with. She didn't, for some reason. I also don't understand why she wouldn't do it, but she didn't. Um, yeah, and she continues to be retarded, as we will see later. And she was already prior retarded, as we see later in the prior statements.